Call this hearing to order. This is the Code Enforcement Special Magistrate hearing of Thursday, June 20th. And I'd like to just, before we get started, go over some of the procedures, just so everyone is on the same page. These are evidentiary hearings, which means that both sides are permitted to present evidence in support of their positions. I haven't spoken to anyone about any of these cases, so if there's anything that you'd like for me to know, if you could, Officer Cole, we have some people. Thank you. I'm going to ask you to check in with the clerk in just a minute. We're going over some of the procedures for today. As I mentioned, it's an evidentiary hearing, so both sides will be able to present their case. And I don't have any background on the case, so make sure that you tell me anything that you want me to know today. And because the city has the burden of proof, they'll be allowed to present their case first. Both sides are permitted to cross-examine the other side, so if you have any questions that you'd like to ask of the witness for the city, you'll be permitted to do that, and the city likewise would be able to cross-examine any testimony that you give. All testimony will be presented under oath and recorded. And if you intend to testify, if you would please check in with our clerk, because she's responsible for making sure that the names of everyone who speaks today, those are kept. And if you present any evidence today, those documents will become part of the record, and you must leave them with the city. So if you want to show pictures or things like that, that becomes part of the record, and will have to remain here. Following the presentations, I'll make a decision on the issue. I'll state what that is, and then we will render an order, and you'll be mailed an order. You have the ability to appeal the order if you disagree with it within 30 days, and that's stated in the order as well. And these hearings are electronically recorded on video, so when it's your turn to speak, if you would please step to the podium and state your name clearly for the record so we can make sure that we keep that. I think that's it. If anyone here at this time intends to testify during any of these cases, if you would please stand to be sworn in. Please stand and raise your right hand. Do you swear or affirm that the testimony you will offer today will be the truth and nothing but the truth? Please be seated. All right, if we're going to go, are we going in order on the docket? Okay. Then Circle K Stores, case CE 13-000669.
All right, good morning, Your Honor.
Good morning.
I'm Monica Cole, Code Enforcement Officer for the City of Oviedo. This is for case CE 13-000669. for 40 Mitchell Hammock Road in the city limits of Oviedo in Seminole County. All statutory requirements have been met for this hearing, and I have a packet of evidence for Your Honor, if I may.
Would you like this to be moved in as city's composite exhibit A? Okay, is there any objection to this being moved into evidence? Thank you. Okay, go ahead.
On April 3rd, 2013, myself and the code enforcement manager observed that the car wash specifically had been redone at the Circle K store, and there were signs placed on it. There are also signs on the outside of the gas pumps, all of which were all erected without permits. On that date, the code enforcement manager called Kevin Champagne, the district manager for Circle K, and advised him that those signs would require permits. I re-inspected the property on April 24th, 2013, and observed that the signs were still erected and no permits had been obtained. On April 29th, 2013, I sent a notice of violation to Circle K, again, advising that they were in violation of LDC Section 14.5A, and that permits must be obtained for all signs erected on the property. I re-inspected the property on May 15th, 2013, and observed that the signs were still erected, and again, no permit had been obtained as of that date. So I prepared a notice of hearing and an affidavit of violation and sent that to the property owner. That was also received. On May 30th of 2013, I received a phone call from a property manager representative for Circle K, and advised again what needed to be done, and emailed her copies of all the notices. At that point, Mr. Paul Stokes called me, and we spoke as well about what needed to be done. I re-inspected the property today, 6/20 of 2013, and the signs are still erected, and no permits have been obtained. Mr. Stokes, representative for Circle K, is here and would like to address Your Honor.
All right. Do you have anything else?
No, ma'am.
Nothing else from the city. All right, Mr. Stokes.
Yes, my name is Paul Stokes. I'm representative for Circle K.
What is your, what's your representative capacity?
I'm a territorial service manager. I oversee the East Coast of Florida.
Okay, great. I'm sorry, go ahead.
No, what we plan on doing is we actually fired the sign company that we did have because they weren't pulling permits, and that's not in this municipality, it's in all of them. I obtained another one, WGN Signs, which is located in Lake Mary, Florida. They took over in May, and they're actually going through trying to get everything permitted. Now they're going back after the fact, trying to clean the mess that we're in. And we just ask that you probably give us 45 to 60 days to go ahead and get all the permitting done, completed. He's going to probably be in the city next week to start applying for it. He was going to attend this meeting today, yet he was held up at St. Pete on another project.
Okay. Well, it looks nice.
Yeah, thank you.
Okay. Does the city have any questions for Mr. Stokes? Okay, then could I ask you to step back up? What is the city's position as to the 45-day to 60-day request?
The city's not opposed to that. As you can see, it does look, some portions are painted, and by the time they go through the plan review. And
Yeah, as things go,
submit plans.
with what comes in front of us,
Yes, ma'am.
it looks nice, but you got to get the permits. Okay, so then what I'll do is I will enter an order asking that this be done. Let's see. July 25th. Do you have the date of the August? August 22nd. Okay, I'm going to enter an order then stating that this needs to be rectified by August 21st. And if not, then we'll be back here for a hearing on August 22nd. Okay. All right, thank you. I'm sorry, I didn't address what the fine would be. What's the request of the city?
The city requests that if it's not done by the compliance date, that a fine of $50 per day be imposed.
Okay, are you in agreement with that? Okay, all right, then I'm going to enter an order that the city has met its burden of proof and that the respondent shall have until August 21st, 2013 to bring the property into compliance, and failure to do so will result in a fine of $50 per day for each day that the property remains in compliance. Thank you. Madam Clerk, I'm going to give you my composite exhibit A. Thank you. All right, moving on, case CE 13-001258. It's the technical things that are the hard.
Good morning, Your Honor. My name is Sean O'Rourke. I'm the Code Enforcement Manager for the City of Oviedo. This is case CE 13-001258. It's in regards to the property at 4021 Safflower Terrace in the city limits of Oviedo and Seminole County, Florida, for violation of the International Property Maintenance Code, Section 14.70 of the Code of Ordinances, specifically Section 303.2, swimming pool enclosures. Your Honor, with regards to notice, I would like to submit the packet of exhibits and go over the first page.
Okay. All right, would you like to move this in as the city's composite exhibit A?
Yes, Your Honor.
Okay. Hearing no objections, I'll be accepted as city's composite A.
Your Honor, there's a copy of Florida Statutes 162.06, subsection 2 is highlighted, the first line, except as provided in subsections 3 and 4. And if you look down at sections 4, which is highlighted under 162.06.4, the code inspector has a reason to believe a violation or the condition causing the violation presents a serious threat to the public health, safety, and welfare, or if the violation is irreparable or irreversible in nature, the code inspector shall make a reasonable effort to notify the violator and may immediately notify the enforcement board and request a hearing. Your Honor, it's my opinion as the code enforcement manager for the city of Oviedo that the violations that I'll be presenting in this case do present a serious threat to the public health, safety, and welfare. That I did make a reasonable effort to notify the violator, and that it is within the statutes to request this hearing on short notice and present the evidence.
Could you talk to me about what you did to get reasonable notice to the owner?
Yes, ma'am. Shall I do that separately or in the process of the case? In the presentation.
Do it in whatever order you're most comfortable with.
All right. Your Honor, the city on Friday, the 14th, June 14th, 2013, was called out for a potential sinkhole. I went out to the property. There was no sinkhole, but I did discover that the pool enclosure, the screen enclosure around the pool was torn. The screen doors were not securing because the pool had popped out of the ground over a year ago. We, in fact, had cited it then, brought it to the code board, a fine was imposed, and the fine was still running. At that time, the screen enclosure was intact, and there was no water in the pool. So when we went out on June 14th, like I said, there was no sinkhole violation, but there was a barrier requirement. At that time, a resident of the property came out, spoke almost no English, through hand signals kind of communicated that they were filling the pool up to try to use it. There was a portable pump and filter system there that was hooked up with hoses in the pool. That person, unable to communicate, dialed a phone number and handed me the phone. The person I spoke to on the phone identified himself as the son of the owner of the property. That person indicated that they didn't know anything about any violations, anything about any pool, anything about any water, didn't know where the owner, his father, was, didn't know if his father lived here, didn't know if the person that gave me the phone was a tenant or just a visitor. Got virtually no information from that person. He spoke clear English, but he just was not forthcoming with any information. I came back to City Hall. I met with the city manager. We conference called into the city attorney, and we elected to take a course of action whereby I would go out that Friday evening, hand deliver the notice of violation and notice of hearing, and then proceed with the magistrate. When I went out there Friday evening at approximately 5:30 p.m., no one came to the door. The sliding glass door in the back that led to the pool was open. I called out. No one came into the back door. No one answered the front door. I posted the property, and if you, I should go back and start with the pictures I took on June 14th. If you look at the pictures, in the upper left-hand corner, picture number 1 is labeled number 1. It shows the lower screen enclosure. The largest screen in the center of the picture is torn and completely open. Photograph 2 is a close-up of that, and that is at ground level, and again, the largest section of the screen enclosure, which makes it particularly accessible. Photograph number 3 shows the opposite side of the screen enclosure, and you can see the upper level screening is blowing in the wind and unsecured, and below that the lower screening is partially torn and open and accessible. And then the final picture, number 4 from that first day, that June 14th day, again just shows the screening open, and the picture is a little grainy, but the door is not seated properly within the frame because the frame is buckled.
And the pool's completely filled.
The full pool is now filled. It wasn't prior to, but on this date it was completely full, correct. This is the notice of violation that was attempted to hand deliver along with the notice of hearing and the affidavit of violation. I posted that violation on the door when no one came to the door to answer. The first picture you have is the general posting of the door, and the second one is a close-up of the documents that were posted.
And that was Friday?
That was Friday, June 14th at approximately 5:30 p.m. I re-inspected the property Sunday, June 16th. There were no changes to the property. Again, attempted to make contact. No contact was made. There's a window open at the front of the house when you go to the door. There's 3 beds on the floor. You can see into the house. The house is always open. The back is, the screens or doors are open, but nobody ever comes to the door except for that first time. And we were there probably 15 minutes before that gentleman came to the door on June 14th. So I don't know if they're in there and just not answering.
The resident that came out?
Yes.
That handed you the phone? Or
Right,
with
correct.
the son?
Yeah, we were there a good 15 minutes before he came out on Friday. The next set of pictures you have were taken this morning by myself. This is an overall shot of the property. You can see how open it is to the neighbors. It's a corner property. There's no adjoining, no fence at the adjoining property to the side or to the rear. This is just the second picture is another close-up of the screen in the same exact condition prior. The pool is still full of water. And then the last picture, no wind this morning, so that is not as demonstrative with it blowing, but it's still, it's exactly as it was on Friday. There's been absolutely no repairs made. You can see where the door, if you look closely, doesn't seat into the frame. So In conclusion, the city believes that this does present a serious threat. We would request that the magistrate order compliance within 24 hours, and if not, authorize the city to take whatever steps are necessary to correct the violation. And then, of course, we would lien the property for the services rendered if it came to that.
The property appraiser has it owned by Olga Medvednik.
Yes. And a check of the city clerk records don't show any foreclosures, any list pendants.
On the property appraiser site, does it have the address for notices as this property address?
Correct, 4021 South Flower Terrace.
Okay, so there's not like another listing
No, ma'am.
of anywhere to reach the property?
No, ma'am. And they have water in her name, and the electric is on at the house.
Well, notice, as you know, is just a really important part of due process. So I think that we have to err on the side of making sure that we've done what we need to do to get notice to people of these hearings and of the violations. But my reading of the statute, I believe that if it is your opinion that the violation presents serious threat to public health, safety, or welfare, then that then allows us to, rather than looking at 162.12, we look at 162.06, which says that you have to make reasonable efforts. And I'll tell you, I agree with you in your assessment that this is a serious threat because there's not any fence at all around the property. It's just this screen enclosure that's really, I mean, even on the lower levels where a child could walk right underneath that metal, there's just absolutely no barrier at all to a completely full swimming pool. So because of the threat to the public welfare and your 3 visits out there plus phone calls and the posting on the property, I believe that is reasonable notice. So, and just to be clear, there's no one here attending the hearing.
Correct.
Okay, on behalf of them.
There is no one.
So, okay.
I did knock on the door this morning in an attempt to advise them also. I took the photograph. Same situation. The house appears open, but nobody answers the door.
Well, I think it is serious. I think that you have made reasonable efforts, and I'm going to find that the respondent is the legal owner of the property and that the city's met its burden in establishing that the property at issue is not in compliance. I'm going to order that the respondent shall have 24 hours to make the property, or to bring the property into compliance, and failure to do so will then allow the city to take the steps necessary to correct the problem and then forward that cost onto the property.
Thank you.
Sign it today. Thank you. Okay, do we have anything else on the code enforcement issues? Okay, then what we'll do at this time is then close the code enforcement hearing, and then I think we have some technical things, and we'll restart for the